Hello there, and thanks for joining the Tuesday edition of Journalist Hangout. I'm Ayodele Ozuwakun, your regular host on the show. Today on the program, Atiku PDP file appeal against tribunal judgment at the Supreme Court. CJN talks tough on independence of judiciary, warns against disobedience of court orders. And later on the show, Tribunal upholds Governor Sanwo-Olu's election, dismisses Labour Party's petition as Masari Ihedioa also win. I'll be hanging out with Mojid Jamiu and Olayinka Oyegbile. Olayinka, it's so nice to have you again.
Yeah, it's nice to be back.
BKO will be joining us from our Abuja studio. Babajide Kolade Otitoju is in Abuja to hang out with us today. So if you are ready, let the hangout start now. Now, for an average Nigerian politician, optimism is a quality that constantly runs in their vein. Now, after suffering a defeat at the Presidential Election Petition Tribunal on the 11th of September, the candidate of the People's Democratic Party, PDP, in the 23rd February election, Atiku Abubakar is not giving up. No, not giving up. Atiku and his party have filed an appeal against the judgment of the tribunal at the Supreme Court. His lawyer, Mike Ozekome, said the appellant wants the apex court to void the tribunal's judgment and upturn the election of President Muhammadu Buhari. It is still one more hurdle to cross in this challenge. MJ, after the election, a lot of issues were raised before they went to the tribunal. It started with the server story, that there's one central server. So all hell was let loose about this server. From this server, it now went to the certificate of Mr. President, and a lot of back and forth came into that. But the tribunal, in giving their judgment, actually succeeded in trashing all this one by one. And at the end of the day, from after 9 hours of judgment, a lot of people were saying, wow, this is like a comprehensive work. But they never say die spirits with politicians, and being an extension of his constitutional rights is that there's still an opening. That's the apex court, the Supreme Court. After the Supreme Court, no more. Go and re-strategize for 2023. But right now, we still have an element of hope that Atiku Abubakar is going to the Supreme Court, and he feels that he could still marshal out his case in the Supreme Court.
Yeah, like you said, it's his constitutional right to exercise by going to the Supreme Court, which is the last, with the apex court as far as cases are concerned in Nigeria. And for keen watchers of our judicial process in Nigeria, you will know that the Presidential Election Petition Tribunal was a very, very tight one, the judgments given. And like a justice was lecturing me on how the tribunal, the appeal court, and the Supreme Court, how they work. Now, it is, in the case of the Presidential Elections Petition Tribunal, it's just 2 layers, the appeal and the Supreme. Now, it is only at the appellate stage that you have the privilege of having an interface with all manners of witnesses. You can bring in evidences and what have you.
Really?
Yes. So now at the Supreme Court, it is only a written submission from what you deduce from the judgment. Now, I've read the 66-count petition filed by Michael Zekome on behalf of PDP and Atiku Obi against Buhari, APC, and INEC. What are they saying? Key issues still on the certificate, then also on the INEC server. Now, they touched a little on the issue of witnesses, that the evidences given by the witnesses were not taken into cognizance by the Presidential Election Petition Tribunal. But then I also monitored the 9 hours judgment, and I've read the 256 pages of the judgment. And what the lead judgment, I mean, it was a unanimous judgment.
Everybody was on board.
What they emphasized was the fact that there's no way election can hold in more than 200,000 polling units, and you are complaining in about 140,000 polling units. You are bringing just, you filed for 400 witnesses. At the end of the day, you called just 62. And even the 62 that were called by PDP, they were saying that they were being told they were not present at the polling units. Then in the case of the certificate of the president, they said the WAEC registrar said it was not the one that signed the certificate.
Okay.
Of course, there's no way WAEC can sign for a certificate issued by Cambridge.
Okay, Mujid, let me just pause you there. Yinka, quickly before we go to Abuja, I want us to look at it holistically. Now, this issue of you have to prove beyond reasonable doubt. Now, it might be putting anybody that hope in the judiciary that want to go to courts to obtain a kind of one form of injustice or the other. Now, what they are saying is that you have to get material witnesses from virtually all the polling units or all the major polling units to put together according to that judgment and present that it must be beyond reasonable doubt. Is this not making things difficult?
Well, I don't think so. You see, the essence of this is that in every polling unit, all the parties are supposed to have polling officials. What do they call them?
Party agents.
Party agents.
Over 120,000 polling units?
Exactly, yes.
Yeah.
So, if you have party agents in over 1,200 polling units, every of your
120,000 polling units.
yes,
Over
120,000 units. Every of your agents must be able to give you reports that this is what happened in my area, there were infractions, and this.
Eyewitness accounts.
Exactly. But in a situation where you don't have up to that, and there are just few witnesses, 61 out of 400 that you said that you had, how do you join that? That is not even up to half of what you claim to have. So it is important that he who alleges must prove. That is what the law says anywhere in the world.
All right, Babajide, since 1999, let me just put it from 1999 till this time, I've never seen our Supreme Court boldly coming out to nullify a presidential election. I've seen it in Kenya, I've seen it in some other parts of the world, but the Nigerian Supreme Court, maybe for political exigencies, maybe for, I don't know, I have never seen any Supreme Court telling the incumbent, go and do it again. Do you think this Supreme Court will have enough courage to deliver judgment in that direction?
Order a fresh election.
Okay.
When there is substantial evidence of non-compliance with the Electoral Act in the conduct of the presidential election, it will be unfair to say that of those judges before they even begin to hear the matter before them. But just as Oyegbule said, you must prove your case beyond reasonable doubt before those judges, before you can expect to get justice. If you are unable to prove your case substantially, then your matter is dead on arrival. Is what I could deduce from the last judgment was that petitioners need to do a lot more, especially when it comes to the presidential election, petitioners need to do a lot more to prove that indeed they deserve to win. And if you cannot bring a star witness who did not witness infractions committed in the course of the election, he was neither a polling agent, he was not even at any of the polling centers. He was in the situation room of the PDP. So if you were not a witness to all those infractions, how do you begin to talk about them, including infractions that are criminal in nature? You know, so this is what happened during the trial at the tribunal. And for me, a lot of those issues have been brought back again. If you read the 66 grounds upon which they are going to the Supreme Court, the one that I find really intriguing is the claim by the PDP's lawyer that the tribunal claimed that the INEC server was hacked. And the PDP lawyer is arguing that the INEC never claimed so. And INEC never reported that any of his documents got missing. So they are wondering how the tribunal came to the conclusion that the server was hacked. Secondly, there was a testimony of Major General Paul Taffa, which contradicts the President Buhari's claim as to the time that he actually entered the army. The time was recruited into the army. So they want the Supreme Court to determine whether it was actually 1961 that he got recruited into the army or 1962. But I don't think that even that would be substantial enough to get the Supreme Court to disqualify the president and then give his votes to someone else. But it's their right to go to the Supreme Court, and they have their reasons. So I can only wish them good luck at this stage. Let's see how hard they can work.
Mujid, yes, Mujid, he's saying, Jide is saying, let's see how hard they can work. That means the lawyers of Atiku Abubakar will really need to work hard to prove more.
What I think is that, you see, if you look at when they first took when they first approached the Presidential Election Tribunal, the appellate, the first court in the case of presidential election, it was in March. So it took 6 months of legal fireworks up till September 11 before judgment was delivered. So I think Atiku knows what he's doing, and the PDP, they need to hold their people together to give them hope that something is coming before the real race towards 2023 will start, because it will be very difficult to upturn any of, because those, you can see that when the judgment was being read, the 5-member panel, they will ask themselves, do you concur with this? They will say yes, they all answered in unison on all the cases. And a particular instance is that of the INEC server, which Jide mentioned. I mean, you claimed that there was a result posted on INEC server, and they asked you which server. They said, facts don't lie. When was this server uploaded? They said 2 weeks after election by somebody who had worked in INEC before. And that's what we brought before the Presidential Election Tribunal. So, and like at the Supreme Court now, you won't even have the privilege of arguing any cases. As they have submitted this one now, they will invite APC to file their own cross appeal. And it is based on those two that the Supreme Court will give its judgment.
Listening to that judgment, Yinka, there was a place that, you know, that the court is not a Father Christmas. You're not expecting us to do this and do that. Now, let me take you back to 2007. Yaradua versus Muhammadu Buhari. It's still the same. In 2007,
yes.
I was at the Supreme Court in Abuja, that particular judgment. I think there was a dissenting, I think 2 judgments from the now ambassador of Nigeria to the United Kingdom, Judge Oguntade, yes, dissented. And I think there were 7 justices, I'm trying to remember, that sat that particular day, and how the pattern of which but what Oguntade was saying in order that day, that the paper of INEC wasn't serialized, as in the voters ballot papers weren't serialized. That's how are we going to know that this is not fraud and everything. That's, I think it was 3 to 4 as at that time. So that was the closest in which we got to in trying to, overturn a presidential election petition verdict.
Just as you said in your intro, that Nigerian politicians are incurable optimists, I would like to also add that even lawyers are. And the reason is this: unlike journalists, what you are taught in a journalism school is doubt everything you are told.
If you're in doubt, you check. If you're in doubt, you check.
Now, the reason for all this is, as MJ has said, is also to keep the party together. Because I remember that the week the judgment was given, a newspaper reported that PDP is trying to move against floodgates of defections. And if the PDP or Atiku had come and said that, okay, we leave judgment to God and all that, of course, what will follow would be defections. Going by history in Nigeria.
Some politicians cannot survive being in opposition for 4 years.
So now, for that to happen, for them to keep themselves together, there must be some kindle of hope. And this is what I think is going to happen, is happening now.
So you're not saying that
not sure
they have a genuine case, that's what they're pursuing, and the Supreme Court might likely...
The issue of server, one, is no case. The issue of certificate is no case. I mean, if I were to be... I'm not trained as a lawyer, but
they can't bring new witnesses.
Exactly. If I were to be a lawyer, what you are going to prove is the issue of rigging or infractions and all that. Those are the things you should concentrate your energy on. But because they don't even have proofs, that is why they are clutching at straw. He doesn't have certificate. He doesn't have INEC server. Okay. The INEC has told you that we don't have any server. You are insisting that they have server. So who are you? Where do you see the server?
Okay, our next topic is actually interrelated with our first topic. The judiciary in Nigeria commenced a new legal year on Monday, and both the bench and the bar appeared fired up to advance the cause of justice. Speaking at the special session in Abuja to usher in the 2019-2020 legal year, the Chief Justice of Nigeria, Justice Tanko Muhammad, talked tough on the need to preserve the independence of the judiciary, while reiterating that the Supreme Court, under his watch, will not be subservient to anyone or group. He warned governments at all levels to obey all binding court orders. Let's share the story with you so that you have an insight to what happened.
And 381 of the petition.
The Supreme Court commenced its annual vacation after the 2018-2019 legal year on 29 July 2019. The swearing-in of 38 newly conferred senior advocates is part of activities to mark the commencement of the new legal year. The occasion avails the Chief Justice and other top legal practitioners the opportunity to bring issues confronting the judicial system in the country to the fore.
I am using this medium to appeal to authorities concerned that all levels to free the judiciary from financial bondage as has been subjected to over the years. Let it not just be said to be independent, but it should, in other words, in action, be seen to be independent, truly independent.
The practice of law has consequently become very dangerous and risky. To illustrate, it used to be the practice that lawyers under investigation, and this was far and in between, by law enforcement agencies were routinely granted administrative bail based on self-recognizance. So, what justification is there other than abuse of powers and egotistic humiliation and degradation of lawyers and the legal profession by some law enforcement agencies?
Those being sworn in promise to uphold the tenets of the law.
The senior advocates of Nigeria at the beginning of the legal year, and some new senior advocates of Nigeria were sworn in, and one of them is one of our friends, civil rights activist Ebun Adeborua. Wish him the best of luck.
Congratulations.
Congratulations, Ebun. It's one of ours, and the 37 other senior advocates of Nigeria that just be conferred with that honor. And looking at what Justice Mahmood said, Babajide, Justice Tanko Mahmood is talking tough. He was talking about the need to preserve the independence of the judiciary. And he reiterated that the Supreme Court, under his watch, will not be subservient to anyone or group. That's talking tough. You know, it's related with what you just said in our first topic, and we're trying to look at the independence and the courage of our Supreme Court to actually make landmark pronouncements, no matter whose ox is God.
The CGN said, despite the fact that the Supreme Court, the Constitution emphasizes on the separation of powers, that up till now, he needs to go and beg before funds get released to him to run his office. And he said, and I quote, "If you say I'm independent, but in a way, whether I like it or not, I have to go cap in hand asking for funds to run my office, then I have completely lost my independence." I think that we should take the issue of the independence of the judiciary seriously. One thing made me happy: the decision of the UK Supreme Court against
the Prime Minister.
The shutdown of the Parliament.
The Prime Minister.
Johnson.
Yes, you know, when it happened, there were some Nigerians who were saying, look, Britain that you like to describe as a bastion of democracy, you can see what their president has done. Now, these things get done in Nigeria, you will be shouting, you will be making all kinds of noises. But it makes me happy that for those who were saying that and actually recommending that an arm of government should be superior to another, they've seen clearly now that in Britain, they take their democracy seriously, and their institutions regulate the conduct of stakeholders in the democracy. So we can't have a situation in which one arm of government will be subservient to the other. They are all supposed to be working at the same level. One should never see itself as being superior to others. The federal government has no reason to choose what decisions of the court that it should obey, that it can obey. Once decisions of the court are made, you have every reason in the world to obey the decision of the court. Otherwise, what you are asking for is anarchy. The disrespect of the judiciary has to stop, because they are like representatives of God on earth. For example, where a judge sits on a matter involving life and death, and he takes a decision, he has acted in the place of God. So the judiciary needs to be strengthened. It needs to be encouraged to continue to dispense justice in a very, very transparent and even-handed manner that will suggest clearly that it does not derive its powers from any arm of government. So this is what we want to see. The president set up a committee to help achieve autonomy of the judiciary in the states and the legislature, and the autonomy of the legislature in the states. I would want to see this extended even to federal level. The federal institutions, federal agencies shouldn't subject judges to any form of humiliation, to any form of control, because that would be going against the relevant sections of the Constitution. So I agree absolutely with the CJN that there should be financial autonomy. Imagine a situation in which a governor of one of the North Central states decided not to release the funds of the judiciary because he was not happy with a judgment that went against him. That can only happen in a barbaric nation, and it shouldn't be happening. So this has to stop.
MJ, you just saw what happened in Britain, and the Boris Johnson will be on his way from the United Nations General Assembly now from New York. He has to be in London, so fly back to London with the opening of the verdict of the Supreme Court. Yeah. And in less than 2 weeks, the Supreme Court waded into that crisis and to say, no, Mr. Johnson, you are wrong, that you don't have the power to suspend the Parliament.
Yes, no matter what happens, even if you don't like the face of the legislative arm of government, they are as independent as the judiciary, as the executive, and that's why we have three tiers or three arms of government, so to say. Now, coming back to what the CGN said, he made a particular statement. He said Nigerians are the most litigious set of human beings in the world, meaning any small thing we go to court, even issues that we can settle out of court, that we can arbitrate.
I mean, even go for arbitration.
That is it. So now, the fact is that we just spoke about the PDP going to the Supreme Court. That judgment was too plain. I mean, was too explicit for anybody to want to take it to the Supreme Court. But like,
it's still an extension of their constitutional rights.
The CGN said, it's an enforcement of their constitutional right. But then the CGN said, the Supreme Court of Nigeria is overworked, that all manners of litigations keep coming to them, something that should even have ended at the High Court level. They take it to the appellate court, they still bring it to. So he's seeking for a legislation where those in the legislative arm of government can do an amendment to the Constitution that will allow some of these cases, especially those that borders on interlocutory, to end at the appellate court, so that the burden on the Supreme Court will reduce.
Yes.
I mean, and in terms of a financial autonomy, there is no way our judiciary will be independent, fully independent, if you don't give them the financial autonomy. They are supposed to be on the first line charge. I mean, like the legislative arm, like the National Assembly, where their votes go directly to them, but then you still discover that they still have to depend on the federal government, and at the state level, they are the whims and caprices of governors. The governors determine when to buy them cars, or when to buy them or when to provide them the official accommodation. And you respect these people. I mean, you expect them to send their children to schools. I mean, judges in Nigeria are under serious stress. And I think the CJN you couldn't have put it in a better way, that they need that full autonomy.
What should you do about this situation that Mojid has raised? Yes. If you check out, during the screening of Mr. Festus Keyamo, now the Minister of State for Niger Delta, he raised that particular issue. He said if he were to be made the Attorney General, that it was all about unbundling the Supreme Court. And what you have now is that you have cases that will span from all the states' high courts, end up in the Court of Appeal, and most of them. And he's saying that the Supreme Court is as busy as, I think, 2021 or 2022. Yeah. They have cases running in the Supreme Court. That if we don't unbundle or unburden our Supreme Court the way it is structured now, they might not be able to attend to constitutional matters as speedily as what we are seeing in Britain.
You know, the unfortunate thing is that we have refused to look at other angles of resolving crisis or
alternative conflict resolution, arbitration,
alternative resolution of conflict should be part of our justice system. That look, rather than go to court, let us go this way. Let it be tried there or let it be sorted out there. It is only in a situation where the thing becomes unresolvable that we can begin to go to court, especially to the Supreme Court. You find a case of issue of land cases in Supreme Court 40, 50 years after and all that. I mean, these are cases that should ordinarily not be the business of the Supreme Court because they take too long. And also...
Okay. I have to take this breather. We'll take this break. When we come back, we'll talk more. It's still Journalist Hangout. Stay with us. Welcome back. It's your multiple award-winning program, Journalist Hangout. We're reaching you live from our headquarters here in Lagos, Nigeria Television Continental, and we are looking at separation of power. We are looking at the judiciary, particularly. Now, the judiciary, talking in terms, Babajide, talking in terms of this separation, it's as if in our context in Nigeria, the executive seems to have more advantage in anything. The way the executive wields power. If the executive want to frustrate the legislature, they have the way they go about it. If the legislature or the executive want to frustrate the judiciary by starving them funds and everything, they have a way to go about it. How do we ensure that we have full separation of power as is enshrined in our constitution?
No, we have to keep. We have to keep working at it. Remember, a former governor said that once judges are posted to a state, the first thing they do, they go and see the governor and ask for accommodation. I remember a governor, after losing a court matter, decided to eject judges from their quarters. You know? Yes, in one of the South states, he ejected the judges because their judgment didn't go in his favor. This shouldn't be happening. Now, that financial autonomy is important because when judges have it and all that they require is provided them, they won't have any reason to go cap in hand to the executive because every time you go there, you lose your honor. It diminishes you. When you go before a man to begin to ask him for money, that fellow will begin to see himself as superior to you. And he will be taking actions that in his view you deserve. When in actual fact you do not deserve such actions. We've seen governors. Bukola Saraki decided to sack a judge. And the matter went as Justice Elelu Habib. The matter went as far as Supreme Court. You know, after 2 years, it was resolved in favor of the judge. The truth is, in spite of that, governors continue to imagine that they have the right to choose their own chief judges. And in some cases, even the most senior judge will be bypassed in favor of the junior. Because our governors, a lot of them are guilty of aberrant behavior. Impunity, guilty of impunity. They operate outside of their constitutional powers. So we, as the media, has to keep hammering on the need for us to have separation of powers because that is the only way to protect and defend our democracy. No, once an arm of government begins to usurp the powers of another, then we are in trouble. We are in trouble. The things that happen in other lands that make their democracy stronger, we don't want to do those things in our country. We don't want to decentralize power. Every president that comes into office thinks that, look, if he decentralizes power, that it will become weaker. And this is not good for our nation. So too much powers are concentrated not only at the center, but in the executive. So the executive can actually behave like Louis XVI, who said, "L'estat c'est moi, I am the state." No, you are not the state. You are not the state. We have to keep hammering the point that the CJN has made. And I think also that judges, when they stop taking bribes, when they stop behaving in a manner that diminishes their office, more and more people will respect them. When they stop contracting lawyers to write judgments for them, when they stop giving judgment to the highest bidder, especially judges handling election tribunal matters, election petition matters. So these are judges that we need to talk to, because it diminishes them. They want autonomy. They want to be respected, but their actions will never earn them the respect that they want. Their corrupt nature will earn them the respect that they want. This is the truth. So as we talk to the executive, we need to also talk to the judiciary. There's a lot that needs to be done. The rot in the judiciary has to be cleaned up, and the best people to clean up the rot are the judges themselves, are the judicial stakeholders themselves, not the executive. They have to purify themselves.
The exciting thing for me now is that less than 24 hours after the CJN spoke about the independence of the judiciary and that the judgment of courts must be respected, a court has ruled today now that Sowore should be released. Now let us see what will happen. Whether the SSS or DSS or whatever it is called now will obey that ruling, and let's see what will happen. Because, see, the law is meant to be tested every time. If the Chief Justice says that you must respect all our laws, and an arm of government or a branch of government decides not to respect the law, let us see what will happen and how it will be addressed. Because it has been ruled now that he should be released. I hope as we are in here now, we not hear that he has been arrested or whatever.
Yes, I think the case of Sowore, it was released. I mean, it was the court ruled that it should be released.
Yes.
But that's the DSS. But then, you know, he also has a case of treasonable felony. The first one he was charged with was that of a breach of public peace.
Okay.
So let's see if it's being released.
And they will be rearrested.
so now, Jide has said it all. If those who go to equity must come with very clean hands. We have very, very fantastic members of the bench that are, I mean, you can say they are above board. Then we have those who have soiled their hands. They have put their hands in the cookie jar. Now, well, we can't say all of them are like that. So, but they should live above board. I keep saying something. I mean, when I was growing up in the village, when judges' quarters, nobody dare pass through that place.
In fact,
I mean, they are like, you don't even see them outside.
Yeah.
But you see these days, you see some judges coming to parties, drinking with you, dancing, and even
for society, woman is doing this. They are all there.
They are there. So they should live above. It's like if you choose to be a pope, then you know you are not going to bear children. So that is. You know you are going. You are a judge. Then there are some things you will deny yourself.
Yeah.
So if you do that, then Nigerians will be able to say, yes, you deserve that autonomy, both financial and otherwise.
All right. It is the song and dance of victory for members of the All Progressives Congress, that's APC, in Lagos State. A petition filed by the candidate of Labour Party, Ifegbami Awamaridi, against the electoral victory of Governor Babajide Sanwo-Olu has been dismissed by the State Governorship Election Petition Tribunal. The Tribunal panel, led by Justice Titi Aswa, ruled that the petitioner failed to prove allegations of electoral malpractice against Governor Sanwo-Olu and APC. After describing the petition as a futile and wasteful exercise, the tribunal reaffirmed Sanwo-Olu as the duly elected governor of the state in the night of April poll. Across the country, Governors Aminu Bello Masari of Katsina State, Emeka Ihedioha of Imo State also won at the tribunal. Now,
So also the Nasarawa State, Sule.
yes, won at the tribunal.
Yeah.
I think as we stretch towards that 180 days, most of the tribunals actually gave their verdicts before that technical date.
Yeah.
And looking at in Lagos, I thought immediately Jimmy Agbaje actually congratulated Governor Sanwo-Olu and registered his intention to, work with him and or to wish him good luck that he was not going to court to seek any relief. That was the runner-up in that particular election in Lagos State. I didn't expect any other candidate. As I'm talking now, I know of the Alliance for Democracy. Mr. Olulabi Salis is in court. I don't know, maybe his case has been dispensed of. But the one we have now, Ifegbami Awamaridi.
Yes.
Labour Party.
What's a name? If Egbami,
Awamaridi.
and I don't know his position in that election really, because I know
I'm just even hearing. I'm sorry. I'm just.
I know there were about 35.
Okay, this is Mr. Awamaridi.
So, like the name suggests.
We see those who fought very hard, the Tunde Gbadamosis of this world, that did exceptionally well at the debates, and everything they had, and is from ADP. And Owolabi Salis from the Alliance for Democracy.
Salis is a natural contender.
Yeah.
Just like a Jimmy, Salis has been contesting in the past 4 election cycles.
Yeah.
Now, for Awamaridi, you didn't come first. I mean, you didn't come second or third. I mean, you are at the tribunal. Now, what were the cases he went to plead at the tribunal? That Sanwo-Olu is allegedly of unsound mind, and that he was arrested in U.S. for financial whatever. Now, you see, I think these are some of the things the CGN mentioned, that you don't take the judiciary for granted. Don't bring futile, furious petitions.
He exercised his democratic rights anyway.
No, you see.
I must confess, I'm just seeing Mr. Awamaridi for the first time.
That's why I said.
I don't know.
That's why I was laughing.
I cover politics, and this is the first time I'm getting.
When I heard about the judgment,
face.
the first thing that came to my mind was,
Did
Agbade go to court?
Agbade
Never changed his mind. I mean, Agbade is the one that should have gone to court, because he came second in that election. And you'll have and for this man to even be asking the court to declare him the winner, not even for a rerun. I mean, but then the court was very straightforward. It said, the 3 members said, it described the petition as futile and wasteful exercise. But I think
that's a strong word.
I think people like this should be given serious costs.
Yeah.
Yes.
Okay, fine, to join.
Yes, fine, to pay to the court, and also
For wasting its time.
For wasting its time. You can't be wasting it. So it will serve as a deterrent to others. I mean, they are not there to joke.
Let's go to another state now. Sweet victory for Emeka Ihedioha.
Yes.
We thought what's the name? Is it Action Alliance?
Yes.
All Progressive Congress. We're going to have a big battle in Imo State.
See, the truth of the matter is that for all this, most of the cases are clutching at straw. Perhaps they are looking at what has happened in the past, that some tribunals have given victory to some candidates, so they want to also test the case. For me, the guy who went to court against Ihedioha, Emeka, what's his other name? Nwosu.
Yeah,
I think he is a lost case entirely. He didn't have any case at all. Because, one, you contested under a party that was already put together, and the kind of influence you think you are going to wield, you never wielded it.
Are you talking about Uche Nwosu?
Yes.
Okay.
So what?
The in-law to Governor.
Yes.
Richard
So
Buhari.
on what ground is he going to make claim to be the one that have won the election? But well, you see, on a lighter note, I think coming back to Lagos now, the issue of Mr. Awamarindi, what I see there is that at least he has succeeded in making us know he is there.
His name.
I mean, we have known his name now. So tomorrow now, as we have been saying, we have all been discussing politics, and
I'm going to go after his phone number and least to have a conversation with Mr. Awamarindi.
We now see that. So for
It's-
me, I think the petition that are going to be entertained should be built on solid ground. They should not continue to waste the time of the courts. The tribunals must begin to rule that maybe sometimes they will have to ask them to deposit some amount of money before their cases are heard. Although we might say that that might be an obstacle to justice, but I don't think wasting people's time is not part of what they should entertain.
Babajide, our friend in Katsina is fast becoming a one-party state with the giant stride of Right Honorable Aminu Bello Masari. Are you surprised in any way that he won at the tribunal?
No, I'm not surprised, but it was actually a split decision at the tribunal. I expected him to win, and he contested against the petition filed by Dan Marke, who is
PDP.
also from Katsina Central, which is a significant population. PDP thought that they did the right thing by picking someone from Katsina Central. But at the end of the day, Masari won the election with a huge margin, and then the case went to court. Masari was accused of not being qualified, not having the requisite qualification to stand for the election. But the judges ruled that the petition failed because the petitioner couldn't provide the facts that was needed to nullify the election. But in the case of the Justice Hadiza Ali Jos, who ruled in favor of the PDP, her position was that there is a difference between Aminu Masari and Aminu Bello Masari. But we all know that this was an attempt. Yes, an attempt at a cheap technicality, because everyone knows who Aminu Bello Masari is. And
He has been the Speaker of the House of Representatives, number 4 man in the country.
Yes, he had been. He was Works Commissioner in that state for years, you know. So it's not someone that we are just discovering. So to come and say there's a difference between Aminu Masari and Aminu Bello Masari, was really not something that I found funny. But at the end of the day, Masari has won. The Hedioha had to battle against three individuals. The candidates of ABGA, the candidates of the APC, and a candidate of AA. But at the end of the day, the judges ruled that it will make no sense to withdraw the certificate of return already given to Hedioha, because that was what the APC candidates in the election, Hope Uzodinma, demanded for, that he was not properly elected, that he did not meet the constitutional requirement to be declared winner of the election. But the judges ruled in Hedioha's favor, and they affirmed that Hedioha ticked all the boxes and that he was duly elected. So they decided that they are going to appeal. And the PDP in Katsina will also appeal. So lawyers will continue to smile to the banks, while politicians who find it difficult to agree when they are well beaten that they should rest, they will continue to pay money to make lawyers happy. So it's boom time for lawyers, and I can't begrudge these lawyers. We tend to see the judiciary as having the last say in determining who genuinely wins an election, and so be it. There are places where petitions were filed that I didn't expect that petitions would be filed in those places. For example, in Oyo State, it was clear that the candidate of the PDP, Makinde, won the election, and he won the election easily. So I was surprised that he still had to be challenged, because if you dominated Ibadan, election in Ibadan, you dominated the election in Okeogun area. These are the two biggest voting blocks in Oyo State. So Makinde dominated Okeogun, dominated Ibadan, dominated Oyo. So how does anyone think that a tribunal would declare him as someone who didn't win the election, when it was clear for everyone to see that he won that election? So in the last election, we didn't have so many litigations.
But
it's like the case that we made. No, you are just introducing him to me.
He was the one hoping to win.
You are the people. It's you and Mojid that are the men about town. So you are the ones who interact. You are the ones who interact with such people. So me, I don't know him. Maybe you will bring us together when I return to Lagos.
Dapo Abiodun actually was confirmed. Governor Dapo Abiodun was confirmed ahead of Honorable, the man from, what's the name of that party? Akinlade. APM.
You see, it's the judges will tell you that the onus of proof is on the petitioner.
Yeah.
And to prove that there was violence, there was malpractices. I mean, look at the way PDP lost. Said they asked those witnesses, I mean, as the presidential election, were you there? They said no. It is what they told me.
Well, will this order not put like a fait accompli on to those people that will say, look, instead of me to go to courts and spend money for lawyers and everything, on election day, is either I win it or that election, it will be a do or die thing. The way we are looking at it now, it's becoming very difficult. On elections that we know that are
some cases
flooded
some
elections.
cases has been
Look at
very difficult in this dispensation.
Look at Osun.
Yeah.
They had a solid case. I'm talking of Ogbeni Rauf time. No, I'm even talking of the Ogbeni Rauf time. They had a solid case. That was why they won the case.
Exactly. I know at that time they didn't have time limits. This 180 days. Ogbeni spent 48 months pursuing his mandate at the tribunal.
Now, if you have a solid case, you are going to win it. But don't depend on tribunal. Tribunal, as they said, is not a Father Christmas. They cannot give you what you ask for. And if you don't have evidence, they cannot give. No judge will help you with evidence. You are the one that will give your evidence, and then it is those evidence that you present that will help your case. So as long as you have that election day, you must have your trusted people as your party agents who will be able to get what.
We have to call it a day. I want to thank BKO especially, because when he told me he was going for 1 week, I said, no, it's not possible. You can't go for 1 week. Just have to just stay in Abuja and do one or two things for us. Thank you, BKO. Thank you. I appreciate this. I expected you yesterday. So thank you. That's Babajide Kolade Otoju from our Abuja studio. And I want to thank you, MJ, Moji Jamil.
Thanks.
for always being there for us. And Olayinka Oyebile,
Thank you very much.
thank you. And that's our offering today. Join us tomorrow for another episode of the program. You can also watch Journalist Hangout on our platforms showing on the screen. We're also on YouTube, youtube.com/TVC News Nigeria. Our feedback channel is Journalist Hangout at tvcnews.tv. I'm Ayodele Uzubakun. Bye for now, and God bless Nigeria.